Welcome to our second lecture covering the topic of OSHA. In our first lecture, we did kind of an overview of OSHA. We discussed the specific standards that OSHA has created, as well as the general duty clause, and we discussed employer defenses. In this presentation, we're going to finish our discussion of OSHA, discussing the prevention and enforcement aspects, also the scope and application of OSHA, and the record-keeping requirements. We'll also talk about workers' compensation law with a particular focus on how workers' compensation can work in the state of Texas. So let's begin. How do OSHA complaints, or what is that path? There's really two paths that an employer can kind of get involved with the OSHA administration. One is via an employee complaint, and the other is by a random inspection by OSHA. I would say that the complaint mechanism is more common. Sometimes the complaints are very thoughtful and appropriate, and they identify genuine problems in the facility. Sometimes they are done to antagonize management because employees know that making a complaint will almost surely cause an OSHA inspector to show up, and that's disruptive, and so it can be a way of getting some kind of revenge against the supervisor with whom they are mad. It can even be done as part of a union campaign. Again, identifying an appropriate issue where there is a genuine workplace safety. Certainly that can happen and can be motivated by employees learning more about their rights via a union organizer, or it can be done simply to disrupt a workplace. Oftentimes an employer has an idea who made a complaint. Maybe the employee has complained about a related issue in the past, and but whether an employer knows who made the complaint or doesn't know, of course, the employer cannot retaliate against the employee. The employer can't retaliate even if the employer strongly suspects that there was an impure motive for the complaint. It's just too dangerous to take any disciplinary action in that way. I suppose if the employee is completely lying and you're certain that the employee has lied to the government official, there may be some possible path to taking a disciplinary action against the employee, but that's very, very fraught, and I would say most employers would just stay clear of that. OSHA does do random inspections, and certainly in certain industries, they're going to be more likely industries that are more dangerous, for example. But relatively speaking, OSHA doesn't have an infinite amount of resources, and so they're going to prioritize the workplaces to inspect. And that's usually going to be places where there's been an accident, that employers had a report, or an employee has complained about something, or it's in an industry where there's a significant number of employee injuries. Most inspections are going to be unannounced, and this is whether there's a complaint or not. The OSHA inspector just knocks on the door. If there isn't an emergency situation, OSHA can be required to obtain a search warrant before it goes upon the business premises. That's obviously a constitutional right guaranteed to us in the Bill of Rights. But most employers do not require that OSHA get a search warrant, because that is not the way to ingratiate yourself to that OSHA inspector. The OSHA inspector is never going to be your best friend. His job or her job is essentially to be looking for violations. But requiring a search warrant is going to make that OSHA inspector think you have something to hide, and it's going to move something that's mildly unpleasant or uncomfortable for everyone to something where the OSHA inspector is kind of ticked off and highly suspicious. And so it's a better practice almost always, unless you really, really, really have something to hide, to go ahead and let the OSHA inspector do the inspection without the search warrant. And that's usually how employers proceed. If an emergency exists, let's say the OSHA has gotten a call from from employees where they're saying there's a real danger, OSHA can proceed in an exigent type situation. So let's look at this case. Can OSHA be liable for the negligent acts of its inspectors whose failures directly contribute to the serious injuries of a worker? And the answer here is no. The fact that OSHA has green lighted an employer does not somehow or another make it responsible because it failed to find a particular error. The OSHA inspection is not a guarantor for the employees. The Court of Appeals held that not all inspections by OSHA need to be painstakingly comprehensive. The inspector probably will miss things, and that's fine. I mean, it's obviously not great, but now, of course, the employer may well be liable to OSHA for fines, and the employee can certainly file a workers' comp claim, or the estate of the employee can file a workers' comp claim against the employer based upon the injury, but the employee is not going to be able to successfully sue OSHA. This case is from the First Circuit. It's not a U.S. Supreme Court case, and obviously we're in the Fifth Circuit. But I can't imagine any circuit not saying no to this. This is a pretty kind of out there legal theory. You don't need to know the name of this case or the holding. Kind of just a common sense idea here. Obviously, employers should eliminate hazards or at least reduce them to the greatest extent possible through engineering, policies, training, administrative controls. Employers should be really proactive in this area, not waiting for the accident to happen and then fixing it for other employees, but by actually figuring out what could happen in this workplace, especially when changes are being made. Well, if we change this system, how will that impact other people and other employees? One way that's really important to address this is to have lots of aspects to your particular workplace safety program, lots of moving parts. Obviously, there will be a policy part, there will be a training part, there will be a complaint or suggestion box part. You'll also have things like a budget for innovations and things along those lines. So there's lots of pieces to this, and it really involves lots of communication between different areas, the HR area, management, the line workers, the engineering department, if there's an engineering department, the accounting department, and really just all the different parts of the organization need to be in communication, need to be supporting each other. And they all, at the end of the day, need to buy into the idea that worker safety is the most important thing, more important than profits, more important than customer service. It is an essential part of what we're doing there. Safety rules should be clear, specific, consistent with one another, and strictly enforced. Again, as we talked about in the first lecture, if you have a safety rule and you have an employee who violates it, you got to lay down the law. You got to be strict. You got to say, you're suspended for a week or whatever the consequence is, so that everybody gets, oh, okay, I don't want to break that rule. Because every organization has rules you can get away with breaking. And every organization has rules you can't get away from breaking. Most companies aren't going to let you steal from them, but most companies are going to let you occasionally be less than completely productive at work or be a minute or two late every now and again. So yes, there's rules that you can break and rules that you can occasionally break, and there's rules that you never can break. And you need the culture of your organization to be, I can never break a safety rule. I got to do it this way, even though it's a hassle, even though it takes more time, even though it requires me to use uncomfortable equipment. I know if I bend this rule, I'm going to be out of here real quick. And so the strict enforcement is really important. And of course, you have to be consistent. You can't strictly enforce against one segment of the workforce and not strictly enforce against another. You need to do it against everybody. And it's a good idea to have a policy in effect. Okay, maybe you give a final warning the first time the person is caught violating it. The next time, maybe a week suspension. The third time, a termination. That could be an approach, but it needs to be very strong communication. The policies themselves have to be clear and they have to be communicated clearly. You want these policies to be written at a level that all of your workers can easily understand them. If you have a workforce that's mixed, you need to tell your client, mixed in terms of different languages, you need to tell your client, translate into other languages. If your workforce has a large Vietnamese language population, have that translated into Vietnamese, et cetera, et cetera. You may not translate everything into every single language, but safety stuff is an area where you want to make sure everyone understands it. Similarly, if your client has an employee who is hard of hearing or who would benefit from a sign language a communicator, it's safety times where you really, really want to have that communication. You want the policies to also be specific. Every single detail of the safety procedure needs to be communicated. And ideally, one-stop shopping. Have all the safety stuff together so that a person doesn't have to hunt around for this. And here's an example of workplace safety programs and the components of these. Let me flag a couple of ones that are especially important. Assign responsibility for safety issues. Things that people are held responsible for get done in an organization. And so you need to have somebody who's a safety coordinator. Maybe that's not their title, but if there's an uptick in the number of accidents, that person's rating goes down. If that person doesn't complete all the training that's supposed to happen, that person's rating goes down. There needs to be people who are accountable for that. And usually it's going to be more than one person. That should probably be a part of every single supervisor's appraisal rating to some extent, if it is an industrial type workplace. I don't mean to say it's the only thing they're measured on, but maybe they're measured on, 7 different elements. Well, one of those elements ought to be, what's the safety record in your program? Now, this can be dangerous, though, because what you don't want to do is motivate these supervisors to hide workplace injuries, because, of course, some workplace injuries aren't, somebody's lost a finger or something. They're less important or, less serious, let me put it that way. And so if a person says, oh, wow, we've already had 3 accidents this month. If I have another one, it's going to lower my rating. I need to start telling workers to be safe and careful, but also don't report things. So you don't want it to simply be about the numbers. You also want it to be about the training that's provided, the culture that is existing in the workplace. You want it to be a carrot and stick. You want to reward folks who have good safety procedures. And so, yes, there are consequences when you don't follow, but there ought to be positive things when you do follow. A common strategy in this area, our employers will have, they will post, 1,000 days since our last serious accident. And every, 100 days or 200 days, they'll have a little party, where they'll cater lunch and everybody gets to enjoy a free lunch and, maybe some fun activities or things along those lines. It can remind people that, hey, we're all in this together. We all want to be safe, and we are appreciated when we follow those rules. Upper level management needs to be involved. This needs to be something that's not just the supervisor level, but the unit manager, even above that position, is involved in this. And the employees see that this is from the top down. Let's talk about safety and health committees. You'll see this little reference here that you have to make sure you're complying with the NLRA. What they're talking about here is electromation. I'm not going to talk about the electromation course. This is an important one, but it's kind of beyond the scope of our course here. But this is the idea that health and safety groups can appear to be company-controlled unions, because you have workers who are talking about changes that need to be made in the workplace, and then you have the company saying, yes, we agree to that, or no, we don't agree to that. So it sounds a little bit like collective bargaining, and it does require some care in this area so that what is a very good thing, this safety committee, doesn't cross the line and doesn't violate electromation. For that reason, any kind of safety and health committee probably should be run by both by a labor and attorney to make sure that it's current with what we understand the electromation case and its the progeny provide. But even though electromation does throw, a wrinkle in these areas, You can still do them and they're still important to do. Some approaches in this area are committees. And of course, one of the benefits these committees are that employees are going to be much more comfortable following policies that they had a role in developing, or even if they didn't have a role in developing, that their colleagues had a role in developing. Number one. Number two, the policies themselves will be better. The people who are actually doing the work and seeing the hazards are oftentimes the best people to figure out the clever fixes, the clever workarounds. And number three, it communicates very clearly to organizations that this organization really does care about safety and health. And so all around, it's just a really positive thing. Obviously, if there's a union in place, then the union needs to be very involved in safety matters. And usually the union wants to be very involved in safety matters. And this is an area that, since it's a win-win, both the union and the company should be able to present a united front in this area. Another thing that's common is to have employee sessions where employees can ask senior managers. The way I've seen it done effectively is that once a week or once a month, depending upon how your organization works, there will be a representative or two from each department. And that representative will collect the questions from that department and ask those at the session. And there will be a particular part of the session that is about, I mean, it can be about anything. The questions can cover all kinds of issues, but one topic will be, let's talk about safety. What questions do you have about safety? And then the employees who are present, who are not necessarily asking their own questions, but are just asking questions, they will ask the questions and get answers. And then there will be minutes prepared. And so the answers will be included in the minutes. So this can be a way for management to know, what are employees concerned about? Maybe they feel like this policy isn't being safe enough. This is a way to communicate that. Or maybe they feel like while the policy that we have is safe enough, it's cumbersome. There's an easier way of getting to that. Or maybe they feel like there's something unclear about the policy. And so this is an opportunity to clarify it or to make some necessary changes. And of course, having 1-800 numbers, hotlines that people can ask questions anonymously, is also a really good idea. There may be a need in some settings to consult with outside experts about the handling of certain chemicals and things like that. You want to investigate accidents. Why did it happen? What can be done to stop that from happening in the future? You'll want to have self-inspections. Pretend that somebody is an OSHA inspector. And in fact, there are companies of people who are former OSHA inspectors who will come in and show you, well, this is, if I were still an OSHA inspector, this is how I would conduct this inspection. And they will tell you, wait a second, you're great here, here, and here, but these are some areas of opportunity. Give priority to eliminating or abating hazards. Obviously, that's really important. And of course, training is always really important. Maintaining equipment. Don't use equipment that isn't properly functioning, that isn't properly serviced. Make sure that you have an emergency plan. If there's a chemical leak, or if there's a fire, or if something collapses, what are the plans? How are you going to get people out safely? How are you going to rescue people trapped? What is the path, or what is the plan to contact emergency folks, and who's going to help the emergency folks figure out how to get to the right place? All of those things are really, really important. And you can see there are other ideas. And this really does require having a big plan. You're not going to come up with one on your own. Your client isn't going to come up with one on their own. You're going to have probably an industrial hygienist come in and help. There's no reason to reinvent the wheel. There are prepackaged kind of approaches in these areas that very likely a warehouse or an industrial employer is going to want to use. Okay, as we've talked about before, OSHA enforces OSHA, and the Occupational Safety and Health Administration, of course, is part of the larger U.S. Department of Labor. And penalties and abatement orders, which is basically saying stop doing whatever it is you're doing, would be based upon that OSHA inspector's report. Employers who are covered by the Act must maintain records for OSHA compliance. And that's one of the first things the inspector is going to want to look at. The inspector is going to want to see what the track record is in terms of the accidents that have happened here. And he or she is also going to want to make sure that the log is up to date and is being maintained appropriately. And of course, since this inspection is not planned in many cases, you can't ever be behind in doing the OSHA. I think it's a log 300 is the one that I dealt most with. Employers obviously have to inform employees' rights of their rights under OSHA. And the typical way that employers do this is through posters. Once we're done with this slide, I'll show you what a poster looks like. This is an important vocabulary term, a willful violation. This is, of course, when the employer commits a willful violation. It's a violation in which the employer either knowingly failed to comply with the legal requirement or acted with plain indifference to employee safety. So you can have a violation that isn't a willful violation. Obviously, willful violations are more serious. They're going to involve larger fines. And obviously, the implications to your relationship with employees is pretty bad. Employees don't want to work for an employer who has willful safety violations. That's a very, very, obviously, common sense tells you that who would want to work for a company that does that? So it has not only financial implications, but just overall enterprise type implications. Let me show you an example of the poster. You don't have to use this poster, but this is one example. This is the poster that OSHA makes that shows you, um, what the employer rights are and what the employee rights are and what employers must do. And again, this would be posted in a place where all employees would have access to it. Let me also show you where our local OSHA office is, and it's actually in Richardson, so very close to us. You can see right here in very north Collin County, not Collin County, Dallas County. And you can see there's lots of offices throughout the state. Really, all the big cities are going to have offices. So if you, and obviously they have a telephone number, and so you can contact them or stop by their offices. And obviously employees can do likewise. Let's go back to our PowerPoint. So an inspection typically begins with a conference. So the inspector comes in, introduces himself or herself, shows him his credentials or her credentials, and explains what the circumstances are. Oftentimes, if this is in response to a complaint, they will say, well, we've heard that blah, 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 blah is happening, and they may tell more greater or fewer details, but it may not be the whole facility. Now, just because they are seeing one area doesn't mean they won't say, and I also want to see the whole place, And so it can be focused or it can be broader. When the inspector is walking around, the employer is entitled to have a representative, but the representative should simply be there as kind of a shadow for the OSHA compliance officer. The OSHA compliance officer will likely ask him questions like, well, because if it's a big facility, it may not be immediately obvious where the blank blank department is. So it's not unusual for the officer to say, take me to blank blank department or show me where this particular feature of the facility is. And that's fine, of course, for the employer to direct the officer. That makes sense because the employer representative probably wants the officer to be in and out of there as quickly as possible to see as few parts as possible of the facility. And so taking him or her directly to the place where he or she wants to go is kind of in everyone's interest. But the employer shouldn't be really saying, answering questions that the compliance officer has, but basically being a shadow. And the employer is going to be kind of constantly taking, lots and lots of notes. If the compliance officer stops and look at something, well, the employer representative is going to say, where he stopped, what he looked at. If he took a picture, what did he take a picture of? All of those kinds of things. You want to have as complete a record of what he saw and where he went and who he spoke to and what was said as possible. And the inspector may well talk to rank and file employees. That's fine. The officer is going to ultimately create a report. He will probably be taking notes while he's doing his tour. He's going to be taking photographs. He's going to be asking questions of employees depending upon the facility. He may be taking instrument readings such as decibel readings to see how loud the facility is, air quality or water quality readings. The officer may even point out to the employer representative things that the officer has already identified as possible violations. The idea here is that it's going to take the officer some time to prepare this report. If there are violations, let's get them fixed right now. And so the employer representative under these circumstances is listening carefully to what the officer says, but probably is neither agreeing nor disagreeing, just saying, I see what you're saying. I understand what you're saying, or let me rephrase what you're saying to make sure I understand, or something along those lines. But it's a best practice for the employer really not to take a position either in agreement or not in agreement with the officer at this particular point. If the employer does receive a citation, it needs to post the citation near the place where the violation has occurred so that the workers in that area can see what the citation has resulted in. Obviously, this has some really negative implications for the employer. This basically is the employer fessing up that the OSHA personnel said that the employer isn't providing a safe working place for these particular employees. You can imagine how those employees feel. They feel threatened. They feel they're in danger and that they feel that their employer isn't protecting them. Plus, they probably also have some feeling that, wow, OSHA's pretty powerful. OSHA's making my employer post this. I'm certain my employer didn't want to post this. So they have a feeling of, oh, okay, there's somebody out there that's more powerful than my employer that I can go to. And so having one OSHA complaint can spawn more OSHA complaints. And you can see how having OSHA complaints that have resulted in a citation can cause employees to want to seek union representation. They're scared. Hey, wait a second. I don't feel safe anymore after this citation. Or they may have some notion, wait a second, if OSHA could help us in this situation, maybe a union could help us in another situation. So the citation, what does it say? It's going to include the nature of the violation, the OSHA standard that was violated, the amount of money the company has to pay, and the amount of time that the employer has to correct the problem. This is the abatement period. So this way that the employees can be keeping the employer honest. If the employer is required, let's say there's a puddle where some water is collecting, and the abatement period is 10 days, and they can see the date that this citation went up. Well, they can do the math, and the employees know when the puddle needs to be gone, and so the employer isn't going to have a lot of ability to fudge that time. The inspector may well not be back to make sure that the puddle is gone after 10 days, but the employees, of course, can call the OSHA and say, hey, we see this citation. And typically what they would do nowadays, especially with cell phones, is take a picture of the citation and the puddle and show that, hey, it's still going on. And then probably OSHA would be back under those circumstances. Employers can contest citations. They have 15 days, so this is a really quick turnaround time. In that situation, as soon as your client gets a citation, they need to know to immediately send it to to the law department or to the law firm so that that can be worked on. Let me pause here and talk a little bit about who handles OSHA matters. Now, we talked about the differences between labor and employment attorneys, and a significant number of employment attorneys are labor attorneys, and almost all labor attorneys do some employment work, especially in Texas. There just wouldn't be enough work for an attorney to just do labor work. Who does OSHA work is a little bit more mixed. Sometimes you will find people who do EPA work, Environmental Protection Act work, also do OSHA work, because to do OSHA work, especially if it's very chemical oriented or very specific, that kind of stuff, a labor and employment attorney isn't going to have the scientific background to really necessarily know all the ins and outs of this. So labor and employment attorneys know something about OSHA compliance, um, but that's not their sweet spot. And so it may not always be the labor and employment attorney who's handling this. Or perhaps more appropriately said is, not all labor and employment attorneys know a ton about OSHA. But there are some that do. And so that might be a time where if you are working for a labor and employment attorney who doesn't do a lot of OSHA stuff, you may refer that client to somebody in your practice who does do more of that stuff. Okay, let's talk briefly about the multi-employer doctrine. This isn't something that I'm going to spend a lot of time on because it's very industry specific. It really has to do with the construction industry more than probably any other. So what is the multi-employer doctrine? Again, I'm putting a check mark by it because it is a term that you will want to add to Quizlet. So this is when an employer who controls or creates a safety hazard on a multiple employer work site can be liable under OSHA regardless of whether the employees are theirs or those of other employers. So as you can imagine, a construction site, there's lots of different subcontractors and general contractors out there doing stuff. And different employees. So you might have somebody working on plumbing, you might have somebody working on drywall, you might have somebody working on landscaping, lots of different pieces. And if you who are working on the plumbing does something unsafe, it may not be one of your plumbers who's injured. It may be one of the landscapers or one of the drywallers or one of the carpenters who are injured, who isn't your employee. But it doesn't matter. You're still going to be cited because it's somebody's employee under those circumstances. And so it doesn't apply just in construction situations, but that's probably the most common. And this is a case that talks about this. Again, you're not responsible for knowing this particular case. Um, I mean, this kind of talks about this issue generally, but in this particular case, this particular employer, Simpson, Gumpertz, and Heger, had no employees in this work site. I think it was the architect, perhaps. And some people were injured because the instructions to the working crews from the architects were not specific enough. And the Court of Appeals held that an employer must have a material presence at the site to be liable under the law. And this particular company, SGH, did not have very many, if any, workers on site. So the multi-employer doctrine did not apply in this circumstance. It would have applied, though, if SGMH had a significant presence there. So it's kind of the particulars of this fact pattern. Again, you don't need to know the name of this case or the holding, but you are responsible for knowing this concept, the multi-employer doctrine. Okay, now we're going to talk about the scope and application of OSHA. This is a point that I was not completely accurate on during our first lecture, so I want to take a moment and clarify here. I talked about how California and a few other states, but mainly California, has its own version of OSHA, which is significantly more onerous than the federal OSHA. And I implied that there wasn't preemption. I may have even said it. And that's not strictly speaking true. There is preemption. But what happens is that OSHA can give permission to states to provide more generous protections to their workers. OSHA doesn't have to agree to it, but it can agree to it. And OSHA has often agreed to it, again, in the example of California. But you could imagine a more an administration, a presidential administration that was less focused on safety and more focused, say, on a strong economy, might not give states the ability to provide higher levels of safety into the workforce. So there is the possibility of preemption. I apologize for that point of confusion. As we said before, OSHA does conduct rulemaking. We talked about the fact that was a very laborious rulemaking process and it can be fairly politicized. And let's consider the record keeping requirements. The employer must keep a log on a calendar year basis and retain it for 5 years. And these logs have to be available for immediate inspection if an inspector arrives. The log is required to list all recordable occupational injuries and illnesses that have happened in that facility. And the log is specific to the facility. So if there's, it's not a centralized thing. The log actually needs to be kept on site at the facility. If you don't have your logs up to date or you don't have a log at all, that would be a serious and costly violation. Employers are required to record all work-related injuries and illnesses, all the days away from work due to an injury or illness, any instance of loss of consciousness. The employer is required to report to OSHA within 8 hours of the occurrence any fatality that happened at work that is work-related. An employer has to report any inpatient hospitalization, amputation, or eye loss within 24 hours. And I don't mean to trivialize it, but the amputation could be of a finger or a part of a finger or a toe or something like that. It doesn't have to be, a leg or something, although obviously a leg would fall into that category. So these are the types of injuries or illnesses that are covered. Obviously, death. Anytime a person spends days away from work, and again, this could be something like carpal tunnel syndrome. So it doesn't have to be a, oh my gosh, there's blood all over the place type injury. Carpal tunnel, there's no blood anywhere, but it's a repetitive stress injury, so it builds up over time. You also have to list when somebody is restricted from work or transferred to another duty. So even if they don't miss work time, but their doctor says, oh, because of this pulled back or sore back from that injury yesterday, Bob can't work in the shipping department, but he can work in the, packing department. Well, if he's moved to the other department, then that would be a recordable occupational injury. Medical treatment beyond first aid. So yes, if you need somebody to put a bandage on you or to clean you up when you have a scrape, that may not be a recordable injury. But if it extends beyond just basic first aid, then that's going to be a recordable injury. Anytime someone loses consciousness or if a physician diagnoses a significant injury or illness relating to a workplace scenario, that's all going to be a recordable occupational injury or illness that needs to go into the log. We're not going to talk about mine safety and health. For one thing, we don't have a lot of mines around here. Just know that there is a separate statute that protects miners, and that is not OSHA. There's a lot of controversy about this law and about how it's been enforced. Many people feel that the Mine Safety and Health Administration has not been as careful with the safety of miners as it ought to. Obviously, mining, especially not strip mining, but when you actually go in underground, is very, very dangerous and requires and should require a tremendous amount of safety. And those safety standards have not always been satisfied. So if you have a client in that business, obviously you're going to want to really, really monitor what's happening with the Mine Safety and Health Administration and the Mine Safety and Health Act, kind of beyond the scope of this course now. Now we're going to flip from OSHA to workers' compensation. The connection here makes a lot of sense because somebody who's injured at work is potentially eligible for workers' compensation. So the event that's going on your log for OSHA is probably also going to result in a workers' compensation claim. You may have grown up, if you're an older person or more mature person, let me put it that way, you may have grown up hearing people refer to workers' compensation as workmen's comp association. That term, compensation, that term is no longer preferred because obviously there's lots of work women out there, but sometimes you'll see that term out there still. It's just a historical artifact based upon the time where most work-related injuries happened in an industrial setting, and most workers who worked in that setting were men. But obviously, women can be injured at work, and they can work in those industrial settings as well. So we're going to talk about workers' compensation issues. We're going to do a general overview discussing the coverage and defenses available to employers. Then we'll discuss what benefits workers are entitled to under a workers' compensation statute. And finally, we'll discuss the peculiarities of Texas's law in this situation. So let's begin. So here we have a good definition. Actually, we have 3 definitions, so be sure to add these to Quizlet. Let's look at the first one. So first thing to notice is that workers' compensation law is state law. There is no federal workers' compensation statute. So each state is going to have its own little twist and turn on this. So this is very different than OSHA, which is a national standard. Every state is going to have its own deal here. But there's a lot of generalities we can say when we talk about workers' compensation law. So here's our definition. Workers' compensation laws require employers to provide medical care for injuries and replace partially lost, partial loss is okay, partial lost income of employees arising out of and in the course of employment. So you can see there are 2 components. Employers are going to have to pay the costs of the injury, and also if the employee had to miss time from work, there's a need to replace some of those wages. Not 100%. We'll talk more about that later, but there is some scheme involved under those circumstances. Now you can see that there are kind of some terms of arising out of and in the course of employment. These are important terms. Please be sure to add those to the Quizlet. So in the course of employment refers to the time, place, and setting in which it occurred. So if I'm at home and I'm not working, but I'm watching the TV, eating some popcorn or something, I'm not in this course of my employment. That's probably true even if I'm on call at that time. On the other hand, if I'm in my workstation at work and I might be surfing the internet on Amazon or checking out CNN or something along those lines, I probably am in the course of my employment because I wouldn't be at my workstation if I weren't clocked in at work. The next thing is arising out of employment. What caused this to happen? Now, if I had a heart attack, for example, let's say that I had a history of a poor heart and I had a heart attack, but there was nothing at work that would have caused me to have a heart attack. I could have just as easily been at home when I had the heart attack. Then probably that heart attack did not arise out of employment, even though it was in the course of employment. I was at work when it happened. So you can see here we're looking at the cause. On the other hand, if I'm working on an assembly line and the belt on the assembly line disconnects from the conveyor and hits me and I'm knocked to the ground and get a concussion, well, obviously in that situation, I satisfy both the course of employment and arising out of employment components. Now, you may think, well, these seem pretty obvious terms, but they have resulted in so much litigation. The terms are not nearly as transparent as you might think at first glance. So another important factor to keep in mind when we're talking about workers' compensation laws is that they typically have an insurance component to it. Employers can't just say, well, I mean, they can in certain situations, but because there are some employers who are self-insured. They're large enough, they're solvent enough that they will not need to buy an insurance product to manage their workers' compensation situation. But even then, of course, those employers have to comply with state law. And probably many states still require even a self-insured employer to use an insurance company to administer the program. The concern is that if the employer is administering the program and is acting as a self-insurer, that there is the potential for employers to deny claims that shouldn't be denied. But if you've got, say, Liberty Mutual, um, who administers the program for everybody, and in some sense, it is being paid. It's not being paid premiums and then it's going to pay out money. All it's being paid for by the employer is administering the program. So its staff at Liberty Mutual, for example, that's just one company, who administers the program for this particular employer, the employer is paying those people's wages, but the employer is directly paying the employees through the self-insurance aspect of it. In some states, the employer has to pay through a state agency, and so there is no self-insurance option. In some states, the employer can choose between private insurance and the state insurance option. And again, in some states, there is the option of the employer also being self-insured. We'll talk about Texas and Oklahoma, which is a completely different model. But I want you to be familiar with how the other 40 states work, because very possibly you'll have clients that have businesses in those other 48 states as well. So most state laws provide employees with an exclusive remedy to be compensated for work-related injuries or occupational disease. So exclusive means it's the only one you get to use. The way I like to think about this is kind of silly, but the way I like to think about it is, if you are seriously dating somebody, you want them to consider you to have an exclusive relationship, right? He's my exclusive boyfriend or she's my exclusive girlfriend. And so that means you and that person are only dating each other, right? Well, this is the same idea. If, or in states that have this system, which is 48 of the 50 states, as far as I know, there's not anymore, but I mean, there could be another one. An employee who is injured at work has to use the workers' compensation system to get relief. Also, the employer is going to be required to use the workers' compensation system to figure out whether it has to pay the employee or not. That's the only game in town for these situations. Now, Texas and Oklahoma are a little bit different. In Texas, you can do something called going bear. It sounds a little racy, doesn't it? Sounds like a topless or something. But no, it's nothing racy or anything along those lines. What it means is the Texas employers have the option to not buy workers' compensation insurance. If they go that route, they become what's called non-subscribers, meaning they don't subscribe to workers' compensation insurance. So going bear and being a non-subscriber are the same thing. Those are synonyms. About 20 to 35% of all Texas employers are non-subscribers. So it's a very significant portion, but it's certainly not the complete community. I was actually surprised to see the number was this low. I'm not 100% sure I think that's true. I always had the impression that it was over half, but I'm not going to ask you either way for the number. But whether it's 20% or 60%, it's not a small percentage. And so you might say, well, how can Texas employers make this choice? And the bottom line is, okay, so let's stop and talk. We talked about how workers' compensation law is the exclusive remedy. Let's first of all talk about the system that existed before we had workers' compensation law. So let's go back to, say, 1900, before we had any workman's comp statutes. Well, in that situation, let's say I'm a worker and I'm working in an industrial setting. Obviously, back then, industrial settings were not at all safe. They could be very, very dangerous. And so lots of people got injured. Let's imagine that I am working in one of those facilities, and on my first day at work, somebody's finger gets lopped off in the machine that I'm using. I need this job. I need to feed my family. And so I decide to continue going to work every day. I'm scared. I don't like it. I don't think this is right. But this is the only employer locally that I can get a job with. And so, of course, I'm going to stay because I've got to eat. Well, my decision to continue to go to work once I'm aware of the risks means, under tort law that existed in 1900, it meant that I assumed the risk. I knew the risk, and I continued to go to work. I mean, I wasn't required to go to work. I could have chosen not to go to work, um, but because I chose to continue to work, I assumed the risk. Many times, people who are injured at work are injured not because of their own carelessness, although sometimes that's the case, but because of some carelessness on the part of another employee. That employee did something a little bit not safe, and that kind of snowballed into another person being injured. Under the fellow servant rule, if that worker caused my injury, I'm not going to be able to sue the company under those circumstances. Also, if I contributed in any way to my injury, I'm not going to be able to sue under those circumstances. Contributory negligence is the idea there. Again, this is at 1900. Now, there might have been just a few scenarios in which the injury I experienced was not foreseeable, so I hadn't assumed the risk, and it was completely the employer's fault that the injury happened. So, I mean, there were a few times that employees were actually able to successfully sue the employer, but the vast, vast majority of employee injuries, one of those three defenses that I just talked about, actually, let me show you. I think I have them listed on another slide here. Oh, here we go, defenses. Yeah, here we have contributory negligence, assumption of the risk, and fellow servant rule. So contributory negligence is when I, the injured person, failed to exercise reasonable care to some extent. Maybe I'm just 1% responsible and the employer is 99% responsible. But it used to be the case that me being even just 1% responsible meant I could recover nothing from the employer. Again, assumption of the risk is when I know about the risk and yet I continue to go. That was another complete bar to me recovering back in 1900. And they wouldn't have even required that somebody actually be injured. If I could just look at the equipment, look at the setting and say, you know what, some bad things could happen with that machine over there. I now know about the risk, and if I keep on coming to work, I am not going to be able to sue if that machine actually does injure me. And we talked about the fellow servant rule. A defense based upon these facts. An injury occurred on the job and was caused by the negligence of another employee. So these are some defenses. We'll talk more about no fault later on. So you can see in 1900, it was really difficult to for a seriously injured worker to successfully sue the employer. It rarely happened. And so reformers started saying we need to come up with some other system, some way to get these workers money that they need after they're badly injured. Because sometimes people, would be injured to the point they'd never be able to work again. And so this was a scheme, the workers' compensation scheme. It was designed to give the workers some money to take away those defenses. So now employers were no longer going to be able to say, we don't have to pay because of contributory negligence. We don't have to pay because of assumption of risk. We don't have to pay because of the fellow servant rule. But so that's what the employers were giving up in this scheme that I'm talking about. But the employees also had to give something up too. They weren't going to be able to get punitive damages. They weren't going to be able to get a ton of money. They were going to be able to get a little bit of money, enough money to get their medical bills paid. But honestly, they weren't going to be able to go to any doctor they wanted to. They were going to have to go to an approved doctor, and they would have to get procedures approved. And sometimes procedures that some doctors thought were smart wouldn't be approved by the workers' compensation carrier. Plus, they wouldn't get complete wage replacement. They would typically get, it varies from state to state, but anywhere from, say, 60 to 75% wage. Usually those wages were not going to be taxed, so they were not as cut as you might or otherwise think, but still it wasn't 100% wage replacement. So the employee wasn't getting as much as he could under the best case scenario under the usual tort system, the non-workers' compensation system, but he was able to get some relief and much more reliably be able to qualify for that. So that's how the workers' compensation schema worked. Now in Texas, we still have that same system that we have in the other 48 states. We still have the option for an employer to sign up for workers' compensation insurance. And again, according to the statistics that I've observed or saw, more than half of Texas employers still choose to participate in the workers' compensation system. But a significant group say no. What we want to do is go back to that old tort system. Now, one of the things about that tort system is going to be that these defenses aren't going to be nearly as much available. For one thing, contributory negligence has been replaced with comparative negligence. But this isn't a tort class, and I'm not going to get into the weeds on this. Just know that generally speaking, the employer isn't going to be able to advance these defenses except some milder version of contributory negligence. As I said before, Oklahoma has a system similar to Texas. Obviously, if the injury occurs during the employee's personal time away from work, workers' compensation would not apply to the injury. And of course, the burden is on the employee to show that the accident arose out of his employment. Again, we're seeing arise out. That's a key phrase. And we've talked about the different ways that employers can pay for the insurance. Let me flag this insurance rating term. Again, we've already talked about it a little bit. Employers who have more workplace accidents pay a higher insurance rate. It's a little bit like if you're in a lot of car accidents, your auto insurance goes up. Same idea here. And so employers really value having a low insurance rate and experience rating so that they can pay less money under those circumstances. We also see experience ratings being important for unemployment tax situations. Employers who rarely terminate employees have a very low experience rating. Employers who often terminate employees obviously get a lot more unemployment claims filed against them, so their experience rating goes up, like the car driver who's oftentimes in accidents. The idea, of course, behind experience ratings is that's going to motivate employers to provide safe work environments, both for OSHA compliance purposes, of course, but also to reduce their experience rating for workers' compensation payments. Okay, so now we're going to talk about coverage, workers' compensation coverage. So again, workers' compensation is provided mostly on a no-fault basis because we're not going to parse and figure out, well, how much of it was the employer's fault? How much of it was the employee's fault? How much of it was the coworker's fault? Unless there's true horseplay going on and people really doing dangerous stuff, even if the employee significantly contributed to his injury, it's still going to be something that he or she is going to be eligible for workers' compensation. The employee, even if he contributed to the injury, is still going to be able to collect his workers' compensation payments. And again, as we talked about, the employer is giving up his right to allege contributory negligence, the fellow servant rule, and the assumption of the risk. Now, one exception to the employer liability situation is when the injury is intentional. In that situation, when the employer is complicit in making the workplace unsafe by removing safety features, perhaps in the hopes that that will make his workers work faster, then if the employee can prove that, then the employee can very possibly sue, not just through the workers' compensation system, but sue under tort theory and possibly get punitive damages and more recovery. This is not a common path for employees to pursue, and it would probably only be used in pretty egregious situations because workers' compensation is definitely the default setting. So let's say, a lot of workers' compensation injuries obviously have to do with automobile accidents. A lot of OSHA injuries have to do with automobile accidents or truck accidents or something like that. So, what about employees who are injured on their trip to or from work? Are they entitled to workers' compensation? The general rule is no. If I am leaving my home in my own vehicle to go to my place of employment, and while I'm traveling, all I'm focused on is getting to work, I may be listening to the radio, but I'm not doing work for my employer, then I don't start being eligible for workers' compensation, that is, in the course of employment until I arrive physically at my work site. But there are a few situations that can be looked at differently. For example, if I am in company provided transportation, let's say a bus comes around for my employer and takes us all together, all the employees, and there's an accident in that bus, then probably it would be a workers' compensation case. Or let's say I do various things on my way to work. Maybe I pick up customer orders or I drop off customer orders as I'm going to work. Well, then I actually am doing work at that time. If I am exposed to special hazards due to the location of the workplace as I get closer to that facility, that could be a source of concerns. If I am at work but am, say on break but still physically at work, maybe I'm in the ladies' room or the men's room, or I'm in the break room or the cafeteria or the employee lounge or whatever. If I am on site, then it's probably going to be a compensable situation. So let's say I'm in the lunchroom and there's a puddle, I slip, I fall, I hurt myself. It's still going to be a workers' compensation, most likely. But if I slip and fall because I'm on drugs or alcohol, then probably it's not going to be a compensable situation. So this is an interesting case. The answer is no. If the person who is injured was engaged in significant horseplaying, that's what caused the injury. I'm not going to tell you what. I'm going to skip over the facts because they're kind of gory. But this is a case where if you really are just doing horseplay and you're injured, even if you're at work, that's not going to be an excuse. The court held that Claude Go's injuries were not sufficiently connected with the scope of his employment to be covered by workers' compensation. You don't need to know the name of this course or its holding, and I don't want you to blow this case out of proportion because, the bottom line is workers can sometimes do some horseplay and still have a workers' compensation claim. It's really just kind of the extremeness of the facts of this case that made it one that the court said no, this is a ship too far, so to speak. Okay, so let's consider. Well, actually, I'm not going to dive down into this too much. We said that arising out of employment means that the illness or injury was caused in some way by the job. Here are a variety of different interpretations that various states have done. I'm not asking you to know these doctrines. You don't need to know the particular risk doctrine or increased risk doctrine or actual risk doctrine or even the positional risk doctrine, which is probably ours in Texas. What I'm just trying to show you is these are complicated questions. And so if you're doing work in this area, you need to make sure you're applying the right standard for your particular jurisdiction. But you aren't responsible for knowing these particular standards. We've kind of already covered the defenses. Again, if it's a workers' compensation situation and the employer is a subscriber, then there really aren't very many, if any, defenses that the employer is going to be able to advance. That's they had a lot before the workers' compensation schema was developed, and that really kind of shut employees out of being successful in those claims. But now employers really don't have defenses. So we've talked about contributory negligence. We've talked about assumption of the risk. We've talked about fellow servant rule. Again, if you haven't added this to your Quizlet, be sure to do so. This is our current schema if we're looking at workers' compensation. This is no fault. The legal environment for workers' compensation laws, which means that workers injured on the job are entitled to recover for their injuries without having to prove who was at fault. Um, Obviously, this doesn't mean that no one was at fault. Almost always someone is at fault when somebody gets hurt. It could be a coworker, it could be the employee himself or herself, it could be the employer, it could be lots of different people, it could be multiple people. But the idea here is we're not going to parse that. What we're going to focus on is the degree of injury of the employee. And that really is what workers' compensations are almost always about. So be sure to add this to your Quizlet as well. Some important things that you need to alert your clients to. As soon as an employee is injured, the employee needs to report that through whatever system that the employer has, and this needs to be communicated clearly to employees. Probably most commonly, an employee is going to report it to his or her manager, which is great, or maybe someone in HR. But the manager, of course, needs to know where to send it from there. There needs to be some centralized, at least unit-wide procedure for getting that information consolidated. Employers should err on the side of seeking treatment rather than not seeking treatment. Obviously, the concern of the employee needs to be the first thing on everybody's mind. The employer needs to research it to see what's going on, because there's a possibility if one person gets injured in that way, more people will be injured in that way. And obviously, once the investigation is completed, hopefully the employer can see how that injury can be avoided, or at least the likelihood of that happening again can be reduced. And obviously, an employer should not contest workers' compensation claims unless it has a reasonable grounds for doing so. And most of the time, the employer isn't going to have a reasonable grounds. The employer, obviously, the workers' compensation costs are a cost, and they are a cost that needs to be managed by an employer. But that doesn't mean trying to deny claims that are justified under the evidence presented. And let's discuss workers' compensation benefits. So medical benefits are normally entirely compensable, but and this varies from state to state. Some states require that the employee go to particular doctors, and these doctors then are the doctors for the patient, but they aren't necessarily on the patient's side. In other states, the employee can go to any doctor he or she wants. And in that situation, that doctor is much more likely to be, quote unquote, on the patient's side. If you have that first system where there are set up doctors who do this kind of stuff, that doctor's kind of, like Switzerland. It's not really on the patient side, not really on the employer side. And so there's less need to get second and third opinions. If you have the first system, the employee, can doctor shop until the employee finds somebody who's going to agree with the employee about the circumstance. And there have been doctors out there, I'm sure doctors who've incorrectly denied claims, but also doctors who've granted claims that were probably not, strictly speaking, medically appropriate. And so while all medical expenses are compensable, there can be a lot of gray area about whether a medical expense is necessary under a particular situation. As I said before, there are caps on lost wages. Here are some other benefits that most state laws provide. So there's going to be those temporary disability benefits while the person is recovering, and that's going to be based upon a percentage of the employee's lost wages. Again, 60 to 75% is a pretty common range. Then oftentimes, if the employee does not fully recover, the employee will be awarded a permanent disability rating. It's usually a percentage. So this person is 5% disabled, or this person is 10% disabled. Now, there's actually a schedule. It's kind of a macabre schedule, but it's a schedule that you will see in most state workers' compensation programs that say, if you lose a big toe, you're this percentage disabled. If you lose a finger, you're this percentage. If you lose a hand or an arm, you're this percentage disabled. But most of the time, we're not looking at those situations, or hopefully we're not looking at those situations. So if it's not on the schedule, if it's more of a judgment call situation, for example, somebody has severe back pain. Well, I mean, that's a gray area. It's hard to say, is that a 5% disability rating, or is that a 10% or a 15% disability rating? It requires a lot more fact-intensive review, and that's going to involve having a hearing most likely, and the employee can advance witnesses that will say the rating should be higher. The employer, or more likely the employer's insurance company, can present evidence that might push that number to a lower perspective. Whatever that percentage is, there will be a lump sum payment that employee gets at that time. And at that time, that's intended to kind of take care of that disability for the rest of the employee's life. So the temporary disability benefits will stop at that time. Also, state law is going to provide other benefits like rehab, death benefits if the person passes away, that would be eligible for the spouse or the dependents will be eligible for. In some states, they're mental or emotional stress injuries. That's a big deal in California. In Texas, generally speaking, those are not coverable. An employee who can't return to work may well be eligible for Social Security disability benefits. That's obviously a federal program that is not directly related to workers' compensation. Now, obviously, an employee who has workers' compensation benefits is also protected by the Family and Medical Leave Act if he or she has been employed for at least a year and the employer is covered and all the other requirements are met. Also, that employee can be covered by the Americans with Disabilities Act. So there's lots of different ways that the employee's needs can be satisfied. Workers' compensation is just one of those tools. Here are a few categories of workers who are not covered by workers' compensation. We've already talked about independent contractors. The owners of the business are not covered. Casual laborers, these would be like day laborers. Volunteers, people that are not working for pay. For example, if I volunteer at Frisco Family Services, I'm not an employee, I get injured, I would not be eligible for workers' compensation benefits. And again, of course, as we said before, employees whose employers are non-subscribers. And you may wonder, well, how do I know if my employer is a non-subscriber or not? I'm glad you asked. Let me show you how you would know under those circumstances. Here is the first notice. This is an example of a notice that an employer would use if the employer is a subscriber to workers' compensation. And here is the notice when the subscriber has opted out. You can see this is a non-covered employer. And you'll see the notice is available in English. Actually, I only have it in English, but it's also available in lots of other languages as well. So you post this, obviously adding the name of the employer, or you post this one. And actually, this is for self-insurance, but there's also one when they actually do use, and you can see they have to have a third-party administrator who's usually an insurance company as well. So there's actually 3 posters. I only have 2 here. But these have to be posted in the same area where you see the Title VII poster and the Payday Act poster and the FLSA poster. All of those posters need to be together. I mean, they don't have to be together, but it makes sense for them to all be in the same place. And this is the way that the employee knows, is my employer a non-subscriber or not? Obviously, you can ask your employer, but you can also just look and see what their slides or what their posters indicate. Let's look at this one. This is an example of a individual who was not eligible to work in the United States but was working, and unfortunately he died while he was working. His family, who were living in Mexico at the time, sued to collect the death benefit under the workers' compensation law. Well, the issue was this person who shouldn't have been in the United States to begin with and shouldn't have been working in the United States, but in fact was working in the United States, should that death benefit pay out? And in this particular case, the Supreme Court held that the purpose of workers' compensation is to assist the injured worker, in this case, the injured worker's family. Whether or not the worker is authorized to work in the United States isn't really the issue, so the court let the award stand. You don't need to know the name of this case or its holding. This is kind of similar to the Patel case, you may recall. That was the person who was also an undocumented individual who worked at a hotel and was severely or paid much less than what he had earned. and he was able to sue successfully under the FLSA. Other statutes, the result has been different, so it's a little bit of a mixed bag into whether the employee is going to be able to successfully sue under those circumstances. Okay, so let's look a little bit more about Texas's law. So as we said before, workers' compensation is optional in Texas and Oklahoma, unlike, as far as I know, all the other 48 states. Texas employers can opt out, can choose to go bare, can be non-subscribers of the state workers' compensation system. Again, it's the choice of the employer. If the employer does choose to be part of the workers' compensation system, it's going to work like it works in the other 48 states. The employer cannot be sued, and the workers' compensation benefits are the sole source of compensation for the injured worker after a work injury. But let's assume that the employer chooses to be a non-subscriber. So first of all, of course, non-subscribers are saving money because they're not paying workers' compensation insurance, but they also lose a lot of protections. For example, they can be sued by their injured employees in most cases. And they can also be forced to pay high damage awards if, this is an important word here, if an injured employee can prove to the court that the employer was negligent anyway. So it's kind of, I guess it depends on how much of a risk taker you are if you're the employer. If you're the type of person who's very cautious, or you're the type of employer who's very cautious, you'll probably want to continue to be in the workers' compensation system. If you're an employer who is very careful about making sure the workplace is safe and can stand the risk of a potential, that horrific event that happens that results in a huge verdict. So if you generally are very safe and you can handle the huge, unusual, big verdict, then going bare may make sense. Whether or not the employer goes bare or uses the workers' compensation system, it still has reporting and notification requirements under our state's Texas Workers' Compensation Act. So the reporting still needs to happen. And obviously the OSHA parts of the equation would still be required, just as it, obviously OSHA and Texas Workers' Compensation Law are completely different things. So at this point, we've completed our presentation on OSHA and workers' compensation law. Let's just go over a few management tips. First thing is, worker safety is so important. It's the right thing to do ethically, but it's also the right thing to do financially for your clients' businesses. It's good for morale, and it's also good for productivity. And the fines, you don't want to face it. This is not just a bottom line issue, but again, it has to do with ethics, and it has to do with employee morale. In Texas, there will be a decision that each employer needs to make about whether it wants to go bare or not. And this is not a one-time decision, but a decision that may change over the course of an organization. And a company definitely has the option to revisit this issue. And of course, the employer needs to make sure that all of its units are putting up all of the posters that are required, including the OSHA and workers' compensation posters. I hope that this presentation has been helpful for you. If you have any questions about the material, please don't hesitate to stop into my office hours. I'd be glad to talk to you in more detail about this. I thank you for your attendance and have a wonderful day. Take care.